Hello, everyone. Welcome to our session today with Mr. Ravi Sikri, Senior Advocate.
Hello.
One simple request, please keep yourselves on mute and your videos off for the entire session. Whosoever is having audio issues may have to log in again. Or you can watch us on Facebook Live on Lawyers Club India's page. I will just briefly introduce Mr. Ravi Sikri. Mr. Sikri has been a practicing advocate for over 25 years. He was designated a senior by the Delhi High Court in 2014. He was one of my former and actually my first and my only boss. He's someone who has advised me to advance my law career, legal practice always. He's my go-to senior advocate whenever I'm stuck with a heavy case or a difficult brief. He's an expert with commercial law, arbitration, civil law, labor law, you name it. He's one of the most reputed and sought after senior counsels in India when it comes to arbitration and commercial law. He's appeared and he's been briefed by prominent companies and PSUs. My co-moderator today is Sumedha Dang, who also was working with me in the same chambers. I'll just pass on to Sumedha to introduce herself and to introduce Ravi sir thereafter.
Everyone, a very warm welcome to all of you. Thank you for giving time and joining us in today's session. I am your co-moderator for the session. Like Gaurav mentioned, it was a privilege for me to have joined Mr. Sikri when I had graduated from law school. I was working with Mr. Sikri for a long 2.5 years, and his invaluable teaching guidance has helped me shape my career. He's always been very, very supportive as a senior, and he's always respected all of us. His reputation in the fraternity is unparalleled. He's one of the most sought after lawyers for any arbitral challenge as well as arbitration cases before a tribunal. So before further ado, I pass on the mic to Mr. Sikri to impart his invaluable teachings and guidance to us and his experience in court.
Hello everyone, and I hope all of you are keeping well and most importantly staying safe in these uncertain and tough times. So that's the call of an hour. So I wish everyone be safe. Now, insofar as today's topic is concerned, the scope of webinar of our discussion is Section 34 of the Arbitration and Conciliation Act 1996 and laying a successful challenge of an arbitral award hereunder. Now, although I've been told that a couple of webinars have already taken place touching upon the topic of Section 34 is concerned, but I still, however, I still thought that there is still some scope, to have further discussion on this topic. On the issue of arbitration, coming back to my initial days of practice, there was still 1940 Act was applicable, so I've done many cases under 1940 Act. In fact, when 1996 came from 1996, still 1940 arbitration awards objections continue. So thereafter, then 1996 came into force, and I did matters in insofar as arbitration cases are concerned under 1996 Act, and of course the current amended 1996 Act, which as it stands today. Now, coming back to this. Looking at, to begin with, I must want to point out here, in my career as a student, as an advocate, or now as a senior advocate, I've always throughout followed the stress upon the practice of reading and referring the bare acts. So what happens is today, that is why I hope that all of you are having a bare act keeping handy. Even if it is not there, there's one section only, Section 34, which I am going to refer. And in any case, Section 34, I'll read it. So there's nothing to worry, no worries. I'll take care of it, even if any one of you is not having bare act at the moment. Now, Section 34, insofar as Section 34 is concerned, now Section 34 of the Arbitration and Conciliation Act 1996 provide a statutory recourse to a party to approach the court against an arbitral award where the seat and place of arbitration is India, by way of application for setting aside of the arbitral award. Now, what happens is, insofar as this part is concerned, part first of which comes in Section 34 comes there. Now, this deals with the cases where the seat and the place of arbitration is in India, not it's anywhere else. For example, if it's abroad, then this section in any case is not applicable. Now, on the procedural aspect of filing Section 34 petition, I would like to refer to other sub-clauses of Section 34, because 34.1 in any case tells us what actually these objections are about, which has to be filed under Section 34. But here there are two important, in fact, three sub-clauses are there which would be relevant. But insofar as those three important clauses sub-clauses are concerned, there is one Section 34 sub-clause 2 is the most relevant here, because it prescribes, it lays down that what all objections and in what manner can be filed. In fact, it's a scope which is defined in Section 34.2 is concerned. But however, of late, Section 34.3 as well as Section 34.5 has also become very important. So before I come to the most important aspect of 34.2, let me quickly evolve upon insofar as Section 34.3 and Section 34.5 is concerned. Now, Section 34.3, insofar as 3 is concerned, what it says is, I'll quickly read it from the Act, Section 34.3. I'm not going to read much from the Act, but just a couple of things so that there's no confusion about it. So, subsection 3 of Section 34, which says, an application for setting aside may not be made after 3 months have elapsed, and from date on which the party making that application had received the arbitral award, or if a request has been made under Section 33 from the date on which that request had been disposed of by the arbitral award. Now, it has been this subsection 3 is divided into two parts. Now, what it says is, first it says is that the objections, which is important, once objections are there in place, but you have to keep the most important is the time limit of challenging that award once the award is there. So that is why 33.3 also, subsection 3 of Section 34 is quite relevant. Now, what happens is, in some cases, what happens after the receipt of the arbitral award, a party may have approached the arbitrator under Section 33 for correction of clerical, typographical, or computational error. So these are minor errors which are there, but the little scope is there. Even after the award is given by the arbitrator, you can still go back by moving an application and asking for typographical error or some similar error, where a judge where the arbitrator can look into. In such cases, Section 34 petition must be filed within 3 months from the date of disposal of such request. So here, I would like to straight away explain insofar as this is concerned and make it easy insofar as the relevant law is concerned. Because now what had happened when we think, yes, that every law is in place, but now every now and then, especially in 2019 onwards and 2020, in the initial part of 2020, there are many judgments given by our Delhi High Court, Bombay High Court, and so far as Supreme Court, Honorable Supreme Court is concerned. So that is why now, insofar as Section 34, subsection 3 is concerned, I will try to explain insofar as the time frame, the limit which is there under prescribed limit under which you can file the objection petition, as we call it commonly, or an application under Section 34. Now, in a state of HP, a judgment given by Supreme Court, namely in a state of HP versus Himachal Techno Engineers 2010 12 CC 2010, which was given by Justice Ravindran, it has been held that in term month does not refer to a period of 30 days, but it refers to an actual period of calendar month. So here, when it says it has to be filed within 3 months, so it doesn't actually refer to 3 months means a 90 days. It has to be a calendar 3 months. It can be February, March, April. It can be November, December, January, and the days which comes would be calculated or computed. So sometimes when we have 3 months, it can be 89 days. Sometimes it can be 90 days, or maximum it can go up to 92 days. But here, these 3 months are very sacrosanct. So this is one time limit which is actually to be followed very strictly. Now, what further this judgment which I mentioned, insofar as Himachal Techno Engineers is concerned, it further defines the period of 3 months used in section 34(3) cannot be equated with 90 days. The calendar months may vary from 89 to 92 days. Also, the period of 30 days mentioned in the insofar as proviso, which I'm going to read it shortly, cannot be taken as one calendar month. So it has to be looked into it. Now, coming back to immediately another quick judgment which is there on the subject is concerned, that is Anil Kumar Jinnabai Patel versus Pravichandra Jinnabai Patel, which is again a judgment which was of 2018 by the Supreme Court. And and along with that, there's another judgment which came up during, which was actually previous than this, is State of Maharashtra versus ARK Builders Private Limited. Now, insofar as these two judgments are concerned, the Supreme Court actually stressed upon on the importance of mode and manner of delivery of the arbitral award, which I will quickly try to explain insofar as 3-4 points are concerned, relying on taking cue from these judgments only. It has been held, and insofar as these above two judgments which I just referred, what it says is it has been held that the delivery of arbitral award as in envisaged under section 31(5) is not a matter of mere formality but a matter of substance. Further, it has the effect of conferring certain rights on the party and also bringing an end the right to exercise those rights on expiry of prescribed period of limitation, which would be calculated from that day. Now, the third point which is important here is, since we are dealing indirectly a limitation, so the limitation for setting aside arbitral award is to be reckoned not from the date of the copy of award is received by the objector from any source, but from the date of copy of award duly signed by the arbitrator is delivered to or received by the objector. So what it says is the limitation or the time reckoned or start is when you receive, or the above two judgment says when you receive a type signed copy, duly signed rather I would say, by the concerned arbitrator. So this is one insofar as deals with these three judgments are done, but there is further elaboration. This was insofar as done. This is there was another exception to it is it was laid back in 2000, way back in 2005, when sometime it comes to, when you have a large PSU and they have their offices spread all over the country. What happens sometimes the arbitrator award is delivered in a certain office and it keeps on shuttling from one table to another table or one office to another office without knowing those people who are sitting on a front desk that what exactly is this and where does it, and in that actually the time is lost. Sometimes 3 months is nothing because it's various states also it moves around. So here this judgment, Union of India versus Teco Trichy Engineer and Contractors 2005 Code SEC is concerned, Supreme Court observed and had noted that in cases of large organization like railways etc., because this case involved of railways, the arbitral award must be delivered to a person who is directly connected and concerned with the arbitral proceedings and not merely to any officer of the organizations. So basically this was there when it deals with number of various different PSUs, public sector undertakings. So this judgment was actually delivered keeping in mind the public sector undertakings. So sometimes public undertakings, they do have some advantage if the award is not reached to them. And then of course the 3 months per se, the limitation period will commence from the person who is actually dealing with the matter receives. So there's otherwise in normal circumstances, but these are rare occasions when this happens, because now every day everyone is aware, especially the arbitrators are aware that the advocates who are dealing with the matter or the concerned parties, because it must reach the party also, the concerned address, the exact address, the signed copy of the award is given. So this judgment is hardly being used unless some layman inexperienced arbitrator does some kind of mistake or not aware. But mostly these days the signed copy is delivered, because these days everyone is, all the arbitrators and the parties are taking due precaution. Insofar as once the award is pronounced, it's straight away signed copy should go to the concerned parties. Now, when we talk about this and when we talk about limitation, then comes an important point is condonation, because condonation has to be dealt with it. As we see, 3 months is maximum time which is mentioned is there. But when it comes to condonation, in filing this, the question comes, can we exceed that 3 months time at all? Now, when in my early reference, I said 3 months is a very sacrosanct, but there is one exception to this. And that exception we will deal in condonation, which is, of course, which has been read insofar as this section 34.3 is concerned deals with. Now what happens is, in this, when we talk about section 34.3, and when I said 3 months, now there is a proviso which is given. And the proviso which is given is, I would like to read that proviso now at this moment. I didn't read it that because I wanted to deal this proviso when it comes to condonation is concerned. So I just quickly read what it says, section 34.3. Provided that if the court is satisfied that the applicant is prevented by sufficient cause from making the application within the set period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter. So now when we are talking about the court, the legislature has given us some scope of insofar as condonation is concerned, and that scope has been given in proviso of section 34.3 of the Arbitration and Conciliation Act, says that yes, you still, if some difficulty somebody may have faced, and if he has genuine reason, he missed out the timeline that of 3 months for whatever reason, then maximum further period can be given as 30 days. So in so far as this 30 days is concerned, it has been further elaborated. In fact, there are now, we have, as they say, we have judgment in on almost every topic. So when we come to this, I would like to mention here that the 30 days must not be confused with 1 calendar month. It's other way around. There, 3 calendar months has to be in number of days. It's not 89, I said 90 or 92. Here, insofar as 30 days are concerned, it can't be mentioned at calendar year. Means no 31 days if we are in January or December or July or August. It has to be 30 days. If it's February, still you can add 28 days and plus another 2 days. So it has to be 30 days. So now, insofar as delay is concerned, that's one thing. Maximum, as normally we say, though sometimes it exceeds 120 days, but normally we take it a gap of, in broadly this is a term we use when we appear in the court, 90 days, because it says 3 calendar months. If we normally strictly, we don't, calculate that, and then we take it 30 days. So we reach to this magical figure of 120 days. So we take it as 120 days, but of course, when one looks into minutely, it's better to be under 120 days, and that too, when you are exceeding 3 calendar months, then you better make your case. It's not that you can just, by mentioning 30 days delay, there has to be a justifiable ground. It's not that court is going to condone that just you mention 30 days delay should be condoned. You must make up a case of condoning that 30 days delay. Now coming back to further elaborating this 34.3 when we are discussing, a quick on limitation part. When everyone knows, I hope most of you know at least, that when we talk about limitation, the Limitation Act is very much in place. And in so far as Limitation Act is concerned, Section 14 and Section 5 of the Limitation Act are too relevant. So there are now in applicability of Section 14, but normally when we come to CPC, we take advantage, or in other places we take advantage of Section 5. But in so far as arbitration is concerned, Section 5 is totally not at all applicable here. I make myself very clear here. Section 5 has no applicability when it comes to touching this Arbitration and Conciliation Act. Now, let me quickly tell you, there are 2 judgments also in place. So in any case, this is based on 2 judgments also, but my submission is there at the moment. Now, Supreme Court actually recently, as back in last year 2019, in a case dealing with Section 14 of the Limitation Act is concerned, has given another judgment by Justice Chandrachud. Case title is Simplex Infrastructure Limited versus Union of India 2019 to SEC 455. where it has been said that insofar as the limitation in respect of Section 34 petition is concerned, has again held that having regard to the legislative intent, Section 14 of the Limitation Act 1963 would be applicable to an application submitted under Section 34. So, as we know, Section 14 application is it's a bona fide. You can only take advantage when it's a bona fide mistake, insofar as your petition is filed to some different court of wrong jurisdiction. So here also, though there are earlier previous judgments also, but in 2019 it has been further clarified by the Supreme Court. And it further says that Section 14 of the Limitation Act does not provide for a fresh period of limitation, but only provides for exclusion of a certain period. Which period? Which you are fighting already utilized before some other court or before a wrong forum or a wrong jurisdiction. So only that a particular period which are there, you can take advantage of that, but not over and above. And insofar as Section 5 is concerned, there also the judgment, again the very famous judgment, of India versus Popular Construction, again way back in 2001 it was given, where Honorable Supreme Court held that Section 5 of the Limitation Act is not applicable to proceedings under Section 34, very categorical. So Section 5 in any case has no applicability. So tomorrow you think that you have crossed 103 calendar months or plus 30 days, then still you can take advantage of Section 5, that you have a very valid justification in finding that I'm sorry. It's no court can entertain when it comes in Section 5 is concerned. It cannot be entertained. And Section 14 in any case is an exception. What exception? When you are those period when you are fighting before wrong forum or different court or with like jurisdiction. Only that period can be taken. You can take advantage of. Otherwise, no. So this was in fact dealt with insofar as Section 34(3) is concerned. Now coming back quickly to Section 34(5) is also important. Of it has become important. Otherwise, I must say, because why there's another judgment which has come recently on 34(5) is concerned. Now, what 34(5) actually talks about is, I'll quickly mention. So 34(5), when we talk about 34(5), is, quickly I'll read it. An application under this section shall be filed by a party only after issuing a prior notice to the other party, and such application shall be accompanied by an affidavit by the applicant endorsing compliance with the said requirement. As the section is very well worded in a simple English language, everyone understands. The moment you decide to challenge an objection under Section 34, and your petition is ready within time, before filing it with the court, as otherwise also normal practice is, you have to serve advance copy to the opposite party. So here, when the award is against you, you are filing an objection, and in favor, whosoever is there, if the award is in their favor, it becomes opposite party. So you have to serve initial advance copy of the petition, which you're going to file in a particular court. So that has, over a period, has become, in fact, I must point out quickly here now since the judgment is there. But otherwise, I think as per High Court rules, or since beginning it's in practice, that even the concerned registry asks that whether the advance copy is supplied to the other party or not. Now, court has further defined whether it is actually an advisory or it is a mandatory. So, but there are reasons also mentioned that how it helps when you serve an advance copy to the opposite party. So, in this, a judgment which has come now is given by, and I must point out quickly that this, insofar as Section 34(5) is concerned, has been, though we've been following this practice for a good number of years, we've been doing this, but this has recently been added, 34(5), and has been inserted in the Act with effect from 23rd October 2015, when major amendment took place in 2015 of the Act. Now, the judgment which I was referring is actually State of Bihar versus Bihar Rajya Bhumi Vikas Bank Samiti, given by Justice Nariman, and who clarified Section 5. Of course, when it came in place, so this came in 2018, amendment came on 23rd of October 2015. So what this judgment says is simple, that says it is not a condition precedent, but a procedural provision, and seeks to reduce delay in deciding application under Section 34. So these are the observations, and I must clarify on these observations. Perhaps what happens is when objections are filed, court normally would like to hear, when hearing, instead of ex parte, the other party who is going to be affected if some ex parte order is given, so, or granted in anybody's favor. So better to hear other party also. So that saves time instead of issuing notice and then party appearing. So this is how it says that it's in deciding the application. So further, another aspect which was dealt in this judgment was the requirement of issuance of prior notice to the other party and filing on affidavit endorsing compliance with the said requirement under section 34(5) is directory and not mandatory. So it should be taken as directory, but yes, you must file, but it's not mandatory in case of any emergency or you are unable to serve the other side. Sometimes the other side is not within the same city, it's somewhere else or another state. So you send the copy, normally you post it and it doesn't reaches. So that doesn't mean the court is helpless or not hearing the matter. So court duly hears the matter, or sometimes what happens if the copy is served, other party chose not to appear. So then it happens is, insofar as this 34, section 34, subsection 5 is concerned, it is directory in nature and not mandatory. So this may quickly, insofar as section 34(2) and 5 and section 34 subsection 3 and section 34 subsection 5 is concerned, these are quickly dealt insofar as the limitation, condonation, and 5 serving of advance copy is concerned. Now coming to the main core of so far as 34 is concerned, before I come to this, I must point out that section 34, the law has virtually now settled, and time and again the judgments are coming insofar as 34 is concerned. But yes, there is still some scope. That is why the topic today which has been chosen is, how you analyze where you find the points to challenge it. But in a recent judgment against by Justice Nariman, I quickly refer that judgment, Sanyong Engineering Construction Limited versus NHAI, wherein the Supreme Court has observed that Section 34 as amended will apply only to Section 34 applications that have been made to the court on or after 23rd and 2015, irrespective of the fact that arbitration proceedings may have commenced prior to that date. So what happens when the amendment took place on 23rd, came into bill effect from the amendment took place on December 2015, but came into force effect from 23rd October 2015. So that is why that date is there. Says that even if the arbitration proceedings started before that, prior to this amendment, but the current 2015 Act would be applicable. So this is what this judgment, though I'll be referring to the Sanyong judgment because it is a latest judgment of 2019, where again 34 has been discussed, and I'll be referring to this judgment in detail because it has dealt with entire scope of section 34(2) is concerned. Because now we'll be taking care of section 34(2), which actually lays down the most important points where actually there's a scope of challenge of the award is concerned. Now, insofar as when I talk about section 34, then there are two, again, in section 34(2), there are two important subsection 2. One is section 34(2) and other is 34 subsection 2A, 2 capital A. There's a 2 small a also, but I'm talking about subsection 2, entire subsection 2, and one subsection 2A of section 34. Now, I have made my, cut down this info. Section 34(2) is quite elaborate, so I've cut down 2 points. So I'll be reading my quick points on section 34(2) is concerned. What it says: an arbitration award may only be set aside if the party making the application established on record on arbitral tribunal that a party was under some incapacity. So that's the beginning. That party was under some incapacity. Let's say incapacity can be minor or unsound mind. So those are the 2 scopes insofar as incapacity is concerned. Then number 2 is the arbitration agreement is not valid under the law is subject to. This is itself is quite clear. And 3 is concerned, the party was not given proper notice of appointment of arbitrator or the arbitration proceedings or was otherwise unable to present its case. Again, these are very simple wordings and one understand. But yes, what happens is when party is unable to appear, proper notice not given, which results in ex parte award. So that is why this is there to avoid such eventualities, such conditions. So this is there in place. Insofar as 4 is concerned, the award deals with a dispute not contemplated by or falling within the terms of the submissions of to arbitration, or it contains decision on matter beyond scope of submissions of arbitrator, where, of course, exceed the scope and suffer from jurisdictional error. Then also this covers under such cases covers under this. The last fifth, insofar as section 2A is concerned, is the composition of the arbitral tribunal or the tribunal procedure was not in accordance with the agreement of the parties. Then again, if the tribunal if there is in place, which is against, contrary, or against the terms of the agreement entered between the parties, then also it can be challenged, and of course it will result in successful challenge. Now coming back to another one, part 2 is concerned, of 34.2 is concerned, then it is 34.2b. An arbitration award may only be set aside if the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force, not an arbitrable dispute. So to sum up this, not an arbitrable dispute, and yet the arbitration has taken place. Again, still it is not there, but still one of the party chose to go to arbitration and the award is there. So number 2 is the arbitral award is in conflict with the public policy of India. When I read this public policy of India, I must point out that 90% of the cases are in before this Senyon judgment, and there was another judgment which was given by Justice Nariman, was associated vendors. In that also a public policy has been clarified, explained in detail. So what happens, 90% of the cases I've seen at this ground, in any cases they have taken that the award is, when you challenge the award, this is against the public policy. But when you say that, I will come to that public policy also, you must clarify how it falls under the 4 corners of that public policy, which I have seen many petitions simply mention that the award should be set aside, it's against public policy, but then further they fail to elaborate how it is against the public policy. Now coming back to the other, initially when I said 34.2 is important, and there's another, I said 34.2a, A capital is also important. I'll quickly read the 34.2a also. The arbitral award arising out of the arbitrations other than international commercial. I think in this we must be having a slide, insofar as slide 15 is concerned. I hope you're playing the slide along with that, because all these sections are mentioned in the slide, because the team has really worked hard insofar as bringing those slides in place, and I hope slides are there. So an arbitral award arising out of the arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Now, when we talk about this patent illegality, because earlier it was merged insofar as main arbitration main clause 34.2 is concerned, but now after this 2015 amendment, this ground of patent illegality was, earlier it was, as I said, considered part and parcel to the conflict of the public policy of India, but now it has been added separate and distinct ground, insofar as by this 2015 amendment is concerned. So patent illegality, because earlier orally we used to talk about it, used to be there against the public policy, used to contain, but we used to have this patent illegality, but now it is separately defined. So these are, insofar as broadly, section 34.2, 2a, section 34.3, and section 34.5 are concerned. So coming back to the now important judicial pronouncement, insofar as this section 34 is concerned, and I must say at the outset, then when I'm dealing with section 34, I'm going to refer mostly cases, I'm referring to the cases where the awards have been successfully challenged and where the court has actually interfered with the awards, either setting aside the entire award or partially setting aside the award. So courts have done those cases I'm going to mention, but these are quite latest judgments, because sometimes we think that scope 34 is almost over, but then we come out with a judgment where patent illegality or against the public policy, or which shocked the conscience of the court, then of course, the courts are there very much in order and with open mind to look into it. Now, important judicial pronouncements are concerned. I would be, since I said I would be referring to important judgments of Honorable Supreme Court and High Court, of course, insofar as 34 is concerned, how these judgments and the cases Supreme Court and High Court operate, they have interpreted and applied to the different factual situations. I must say, insofar as my experience is concerned, there's very, hardly any scope in so far as challenging or 34 is concerned, but still, I've come across many cases where I've been able to, with hard work of my advocates who are assisting me, come out with contradictions or come out with some gray areas where we are able to take out those, points which falls under Section 34(2) is concerned when it comes to challenging. Otherwise, insofar as law is concerned, it's very difficult these days. Coming back to this, when I say that very, very orthodox courts are, I want to use a word that courts are very orthodox in looking into Section 34 objections concerned. But still, if you are able to make up your case and you have a good case, then definitely courts are there to listen to you. And if those grounds actually are there, visible, in the award where you can challenge it. So that is why one must make out a very strong case. You can't take it lightly when it comes to Section 34. Very strong case, and it must fall within the strict parameters of Section 34 is concerned. So coming to Section 34 judgment, it's, as I said earlier, also I used that landmark judgment interpreting and explaining Section 34 is concerned is SsangYong Engineering and Construction Company Limited versus NHAI, National Highway Authority of India, 2019-15 SEC by Justice Nariman. This I can safely say, but because it's a latest judgment, this has actually become an authority of Section 34 is concerned, because it has gone into Justice Nariman has gone into in details, have taken a good pain in looking at what kind of award can be interfered with and what should not. So the first is, I'll deal insofar as taking a cue from 34(2) is concerned and mixing it along with this judgment is concerned, is the public policy of India. Now here it is defined that public policy of India would mean fundamental policy of Indian law, which would include violation of the statute enacted for national economic interest and disregarded the binding effect of the orders and judgments passed by the superior courts in India. Now, that's one thing. And insofar as other point which is taken in this judgment is concerned is ground of patent illegality, which is now separately defined. Earlier it used to be public against public policy. Now it's again separately defined. So it has been dealt in 2019, this judgment. Now, ground of patent illegality as available under Section 34(2) A refers only to a patent illegality appearing on face of the award and which goes to the root of the matter. It must not be mere erroneous application of law or a mere contravention of substantive law of India is no longer a ground for setting aside arbitral award. So it has to go, it can't be erroneous, merely a formality. It has to be with substance. The contravention of statute not linked to public policy or public interest cannot be brought within the meaning of patent illegality. So, insofar as the contravention of statutes not linked to public policy and all these points, you cannot just insert into it. A decision which is perverse or so irrational that no reasonable person would have arrived at the same would amount to patent illegality appearing on the face of the award. A finding based on no evidence at all or an award which ignores vital evidence in arriving at its decision would be perverse and liable to be set aside on the ground of patent illegality. If the arbitrator takes into his account irrelevant material and bases his decision thereon, or bases his findings on the material taken behind the back of the parties, such decisions, findings would have to be characterized as perverse. So these are all, I'm reading this excerpts from the SsangYong, taken from the SsangYong judgment of 2019. Now this is one, and now there's another aspect when we file the objections is, violation of principle of natural justice. So this judgment deals with violation of principle of natural justice and how it has dealt with this in a simple manner. That violation of principle of natural justice as contained in section 18 and section 34 2A3 would continue to be ground of challenge of an award. So it has given further scope that if they falls under this, then there is a ground. An award may even be set aside on the ground of breach of due process, which would include instances where the parties are not afforded an opportunity to comment on the evidence and arguments submitted by the other party or otherwise relied on by the arbitrator. It would also include instances where the materials are taken behind the back of the parties by the arbitrator. So these are, one can make out from the reading of these points which are there in judgment, is definitely this amounts to illegality. So definitely courts are not, courts are very much in place sitting there, and if you point out such illegalities, courts are normally bound to look into such. Now coming to this, section 34 2A4 is concerned, again as far as 2A4 is concerned, again I'll pick up the main points which have been dealt in this very judgment. Sanyong is concerned. The ground for claiming that an arbitrator has exceeded his authority would include claim of extra patita, that is traveling beyond the limits of the authority, and also infra patita, which is failure to fulfill the mandate of not exceeding the authority granted, but it must be construed narrowly. So it cut both ways. You can't exceed, and you can't even, you have to live up to that level. You can't even underperform. So I'll quickly explain insofar as this claim of extra patita is concerned. The claim of extra patita, which I think you have Mr. Gaurav and Sumedha, I hope Ms. Sumedha, they're playing that slide 21 so that everyone can look into it. I hope you guys are, slide is very much in place.
Okay. Yes, sir, we will see it.
Thank you. So, insofar as the claim of extra patita would include instances where the arbitrator award a relief that neither party requested, unless the same is subsumed within the relief requested. Now, it would also include an instance, it's an example, where the arbitrator decides, let's say the arbitrator decides issue of or dispute which were not even submitted for arbitration. And yet he looks into it, which is not there, which is not the issue before him, yet he goes and give a decision on something. It happens. It may look, how can someone make a mistake, such, great mistake, but it happens. Many times it happens, we have come across. Then other example here, when it says is extra patita, then comes is infra patita. Infra patita would be entertained by considering the significance of issues dispute not dealt with in relation to the award as a whole. An award may be set aside where the issues which were overlooked were of such importance that if they had been dealt with, the whole balance of award would have been altered and its effect would have to be different. So where what happens, there was something very important when insofar as this infra patita is concerned, which has to be there, but yet the arbitrator ignores. And ignores so much so that such a relevant and important is that if you ignore this, the entire phase of the award changes. When I say phase of the award changes, means insofar as finding is concerned, reasoning is concerned, is going to be effective for sure. Now, that's insofar as there are other points is concerned. Now, there's another point which is there. The last point insofar as dealing with this judgment is concerned is, which is a very sensitive issue, is most basic notion of morality or justice, which also refers to the breach of fundamental principle of justice or morality, either substantively or procedurally, and which, now it's important, shocks the conscience of the court or is clearly injurious to public good or wholly offensive to the ordinary, reasonable and fully informed members of public. Now, quickly giving to this, for instance, examples can be given in this is ground of, crosses of very high threshold and demonstrate egregious circumstances such as corruption, bribery, and fraud. Now, when, of course, somebody has some allegation against the arbitrator, because of these reasons, the award this has been given, which otherwise wouldn't have been. So on this, definitely award is going to be set aside. But I must point out here after saying this of corruption, bribery, and fraud, these are otherwise the most one of the difficult allegations to prove. So here I must say, when I've seen certain objection 34, people are taking this kind of allegations in their objections, but without any substance. So one should only put this allegation in the petition or make a ground of objection in this petition only when they are 100% sure or they have some proof. Otherwise, I'm sorry, please avoid taking this. And this is the Sanyong judgment which I was dealing with. Now, quickly coming to the Delhi High Court judgment, there's another judgment now which was further elaborated in so as further, but of course, the earlier one before Sanyong is given by Justice Bakru, and the case name title is Triune Energy Services Private Limited versus Indian Oil Petronas Private Limited, 2018 SEC, which is online, Delhi 9312. Now, here, this particular judgment has dealt with section 34(2)(a)(4), where the arbitration clause provides for arbitration only in respect of the dispute and differences arising out of notified claims, including in the final bill of the contractor. Any claim, here the court observed that any claim outside the same, which is outside the purview of the arbitration agreement between the parties or outside that, would be an accepted matter. Accepted, not accepted, accepted matter. And in the arbitrator, if the arbitrator still goes on to adjudicate something which is out of the scope or accepted matter, then it would violate section 34(2)(a)(4). So naturally, in that eventuality, award has to be set aside. Now, another judgment which is there is a Bombay High Court judgment titled Bhanumati Jayasukhi Bhai Bhuta versus Ivory Properties and Hotels Private Limited. It's again recent judgment of 2020 and given by Justice Dhanuka. In fact, of late I've been referring this Justice Dhanuka. I must point out few judgments and many objections which are pending in section 34 because he's quite categorically clarified the law to some extent and also has given interfering with the awards where he finds yes there is a scope of interfering with. So this judgment also has some points which to make, which I would be now pointing out or mentioning to you. The arbitral award was set aside as the findings contained therein was inconsistent. In this very case, what happened, the arbitral award was set aside as the findings contained therein were inconsistent with the pleadings of the parties, thereby indicating non-application of mind. So naturally, the award is given is inconsistent with the pleading. It is not there in the pleadings. So naturally, if there is a non-application of mind by the arbitrator, so it deserves award to be set aside. Now, other point which is there in this judgment is the court had noted that the findings were based on no evidence and were ex facie perverse. The arbitrator had even ignored the admissions on the part of the witness. For example, either ignored the part of the witness or actually whatever evidence is there has not been dealt with, which was led by the party. The court observed that the purpose of giving reason is to enable the court to know. Purpose of giving the reasons, when I say reasons in the award, in the particular findings of the claim, is to enable the court to know that the arbitrator has correctly addressed himself to the controversy in issue or has considered the material on court or ignored relevant materials or applied the correct principle, and thereafter on appreciation of evidence has given reasons for the findings and conclusions. The arbitrator had not given any reason while deciding the issues raised by the parties. Now what happens is, if any claim which is decided in anybody's favor, allowed or dismissed, suppose it's a monetary claim, then if it's without any reasons or findings, then it is difficult to understand how a gentleman and a concerned arbitrator has arrived to that conclusion. So that is why reasons should be there in place while deciding any particular claim. In this regard, further, the court observed that the award should speak for itself. Now, this is, one can't say better than this. The award should speak for itself and it should disclose the reasons for arriving at finding of the regarding of the dispute, question of facts and law. I just mentioned before reading this that when you are giving an award, one should know what is going in your mind. Reasons, findings should be there in support of that particular claim so that one understands what exactly is this. Now, further, of course, there's one rider which is there in this judgment is, but then again, looking into broadly says, the court cannot probe into the mind of the arbitrator by referring to material which was neither referred or relied by the arbitrator. The court cannot read additional reasons deduced by some such material. So that is why court is not there, because court is not in any case sitting as an appellate court. So everything has to be there in the award. So that court should understand. If it's difficult for court to understand how the arbitrators arrive to some conclusion, then definitely there is no application of mind by the arbitrator. So coming back to other judgment is concerned, this judgment is actually the third judgment. This is based on documents. And believe me, I've done many cases insofar as documents are concerned where we are able to, sail through when we point out on these documents, and many of awards I've seen with my experience actually lacks insofar as this point is concerned. So we normally, when we are filing, we take advantage of this and we can sail upon. In this judgment which has been given, I'm referring is, the court has made another important observation that the document which is disputed by the party is not proved, cannot be considered by the arbitrator to be on record, or as a piece of evidence. Such document is considered in the award, it would be violation of principle of natural justice. So document has to be there in place, has to be produced, has to be proved. Otherwise, it cannot be read in the award. Another, insofar as judgment is concerned, that's judgment Delhi Jal Board versus VK Diwan. Again, insofar as dealing with the document is concerned, this is 2015 judgment which was given by late Justice Valmiki Mehta, where the short observation which is at the moment is relevant insofar as this webinar is concerned, I'll quickly mention is where it was observed. The court has set aside a part of the award as being perverse, is as much as the arbitrator has awarded the claim, which was reimbursement of some expenses towards the salaries, merely on the basis of self-serving letters without any documentary evidence or payment having been led in support of the claim. So no evidence was led that the payment was made, but yet it was awarded. The court observed, no, sorry, when looking into 5, 7 out of 10 claims, you come to 3 claims, how it has been awarded. There is no substance, no evidence, that no documents in place. How can you award? And though that in this very case, that was part of that award was set aside. Insofar as other next judgment is concerned, this is JN Construction versus Shah Jhaksi Jethabai in arbitration petition, which was before the Bombay High Court is concerned, given at then when Justice Chandrachud was in Bombay High Court. At that time, he gave a judgment which is very relevant insofar as, again, challenging the award is concerned. What was it observers? Quickly, I'll point out. The court, by upholding the setting aside the award, had noted that award did not indicate any evaluation or adopting a particular basis or formula for computing damages. So you have not mentioned what formula you are picking up for computing the damage. You are simply computing without any basis. The court also observed that the manner in which the arbitrator has proceeded to divide the period of delay in execution and to apportion its equality between the parties without any evidence being adduced indicates that the award was founded on no evidence at all. So again, dealing with the documents, it was observed insofar as these are concerned. The next judgment which I am coming is SR Procurement Services Limited versus Paramount Construction. In this, the court also noted that where it is possible to prove actual damage or loss, such proof is not dispensed with, and that compensation can only be given for damage or loss suffered. So what it says is, when the actual proof is available to prove certain damage or loss, it has to be shown. And if it's not dispensed, it can't be dispensed with. You have to show it so that you can sail on it. Otherwise, you cannot simply award it. So many times it happens is that documents you don't put and you don't substantiate, and actually the loss is not suffered, but yet you claim, and on top of it you get it. So such cases needs to be avoided. And when it comes, then actually one aggrieved party is going to challenge. So these parameters have to be looked into. Why? Because I've seen in many cases when the award is given or some amount is given, so it actually calls for a windfall. You know, somebody is not deserving and yet you are giving. It definitely falls under the four core definitions of windfall. So one should not have undue advantage out of it. The award was set aside on the ground patent illegality being in conflict with the public policy. Arbitrator allowed the claim of overheads made on the basis of the Hudson formula without any evidence. Now, insofar as here you have to adopt, some formula, but you have to give reason why you're adopting that formula. Although Hudson formula is one formula which has been readily accepted and happily accepted by the Supreme Court in many judgments. The award with respect to the overheads and loss of profit was also set aside on the ground that the same was overlapping claims. The court noted that the profit can be earned only if expenditure on overheads is incurred, and therefore the arbitrator could not have awarded both claims simultaneously. The next judgment, which is there, is a Patel Engineering versus NIPCO. Now, in this, Supreme Court relied upon Sanyong, relying upon the principle laid down by the Sanyong because it's 2020 judgment, and has observed that the findings taking into account irrelevant factors by ignoring vital process has to be suffered and has to be set aside. Now, there's another judgment which is coming back to insofar as High Court, our High Court, Delhi High Court is concerned, is Sukhbir Singh versus HPCL, which is given by Justice Prateek Jalan. Now, this deals on oral evidence. In this, it has been observed. In this case, the arbitrator had rejected the request of a party for oral evidence to be led on a veracity of and contents of certain documents which were fundamental to the case by stating that the documents had been signed by responsible officer and no motive had been attributed to them. The court observed that merely because no motive had been attributed to the officer, the request for oral evidence could not have been denied. The court also noted that in the duty of the arbitrator approached the dispute objectively and ensured preconceived notion without the credibility, authenticity, or genuineness of other party case, the award was set aside as it fell short of the said minimum standard. So naturally, further going ahead on oral evidence, which is actually important, cannot be ignored. And once it is known, it is amenable to challenge, and one has chances of succeeding. Now, other judgment which is there is Union of India versus Om Construction Company. Again, this is a latest judgment 2019 given by Justice Pratibha Singh, and it has many aspects which has been dealt with, but I think we have little slow, and I think I can be little precise. Instead of going through 7-8 points on this judgment, I would be referring only 2-3 material points, giving my personal experience on that. The first point which is there is the court, after referring to the letters relied by the arbitrator on the issue of idling of staff and machineries, noted that the letters were general in nature and did not give details as to the extent of idle staff and machinery. It was also noted that no evidence had been filed on record to show the actual salaries were in fact disbursed during the period of question and the rental of the machinery was paid. The court observed that the arbitrator had failed to consider the letters written by the department. So here only some letters were taken, unilateral letter of one party, but in the department concerned were ignored. But what happens is that evidence here, the claim was awarded for loss suffered for idling of staff and machinery was given. But however, in this judgment, the court set aside that, saying that there has to be a proper proof when you're claiming damages of idling of staff, and insofar as the salary paid to the staff or machinery is concerned, for employer's mistake or employer's fault, you have to still prove it with the documentation. There has to be a proper document. I'll quickly, coming to this, I must give quick one example. Of late, before this lockdown, there was one case came up where a 5-star hotel was to be built, and a construction company was given by the employer. The owner who wanted 5-star hotel to be built has asked the contractor to build that 5-star hotel. Construction was to take place, but the drawings were to be given by owner's architect. Now, drawings took some time. There was a delay. So naturally, when there's a delay, the construction company came up and said that, look, there was 3 months delay. Insofar as my staff and machine is concerned, they were idle. So idling compensation should be given because for 3 months, I paid rental for the machinery and I paid salaries to the staff, to the laborers who was there in place for be there because I wanted to start my work, but you are at fault. Now what happens? The claims were there in place. Instead of, I'll not touch it whose actually fault was there, whether the drawings were given or not. But the claims was very interesting. It was claimed on the basis that the salaries, it was shown that almost 350 workers' salaries were given and machines and all. It was a good claim, but it was only given on the sheets. I mean, the evidence was there that 350 workers these months and paid this, that's it, type copy of sheets were given to the arbitrator. No further evidence was led in this, and the arbitrator awarded blindly entire amount there. Once the arbitrator pointed, and these were self-serving documents. So in this judgment also is there that you can't grant claim on self-serving documents. In that case, which I'm referring, which I experienced, self-serving documents, and it was still yet to be decided, but however, the notice was issued and the award was stayed on this particular aspect. Now, in so far as other judgment is concerned, it is State of Rajasthan versus Faro Concrete Construction Private Limited. The court held that there's a Supreme Court, I'll give the citation 2009-12 SEC 1 in slide 10. We have a slide in place. The court held that while the quantum of evidence required to accept a claim may be a matter within the exclusive jurisdiction of the arbitrator to decide, if there was no evidence at all and the arbitrator makes an award of the amount claimed in the claim statement merely on the basis of the claim statement without anything more, it has to be held that the award on the count would be invalid. So naturally, this quantum and claim statement it becomes very relevant insofar as awarding some amount is concerned. You can't blindly just award it. Now, another judgment which is there is given by Justice Naveen Chawla. Again, this is a new judgment of last year, 2019, NHI versus Progressive Construction Limited, where Justice Chawla has dealt again, intercepted with the award, and it was set aside because observe that these are the guidelines which were there has not been dealt with. I'll quickly read there what happened in this. On the issue of loss and profit, the court here noted that whether in the facts of the case, party was entitled to claim loss or profit of 10% of the balance work if required to be considered by the arbitrator. Now, what happened? Court was conscious of the fact that court is not sitting as a court of appeal to reappreciate the evidence. However, at the same time, if the arbitrator has drawn an interference from a document which is totally unreasonable and does not even consider the evidence led by the parties, the court cannot act as a mute spectator. Cannot act as a mute spectator. I'll just have a sip of water. Yes, the court cannot act as a mute spectator and uphold such an award. So this is very important when it comes to, again, this judgment also in January 2020, in one of the objections which were filed, and I used this judgment because what happened that the arbitrator totally ignored it. What happens is when I went there and appeared and a remark was made by the judge that, sorry, you have no case. This is an award of 130 pages and given by the retired Supreme Court judge. But at the same time, you was able to give the example, a contradiction. A contradiction where in the preliminary paragraph, it was observed that this party has failed to prove there is no relevant document to claim this claim is concerned. However, while awarding the claim, because for example, 2 crore was asked for in the statement claim, it says, sorry, they are unable to prove their claim. So those were contradictions there in the body of the award. But however, finally, while awarding says, still I grant 50 lakhs. Now, on what basis you are granting 50 lakhs? Nobody is doing charity here. They have to prove it. So that is why on this basis, I was able to get notice issued and the award stood for the time being stayed. The award was stayed. It is yet to be finally argued. Now, there's another judgment which is the last judgment of today, which I'm referring is Dynet Technologies versus Crompton Greaves Limited. Again, this is 2019 judgment. Here, again, where the reasoning is an award is improper, it reveals a flaw in the decision-making process. Thus, where the award is challenged on the ground of impropriety or perversity of reasoning, it may be set aside under Section 34. So we have this judgment also where, there's a scope is there. When you bring your arguments, or you bring your scope in this particular, then the court is there open and looking into it. So insofar as this is concerned, so these are the judgments of which I've read at 34, where the courts have actually looked into and said either partly award was set aside or entire complete award was set aside. So these were successful in getting insofar as the award which was against them set aside by the court. So the trend these days, again, I'm happy because mostly we've been appearing, challenging the award, a concern that High Court and Supreme Court operate in the last 2 years I've seen, where we show, insofar as, especially after amendment of 34 is concerned, then courts are interfering. But you must make out a strong case, and one must look very minutely into the award if you have to really challenge and you come out and you do it. So this is what now insofar as 34 is concerned.
Thank you so much, sir. Thank you so much for an enlightening webinar.
I'm through with my insofar as objections under 34 sentence and petition.
Thank you, sir. So we'll just take a few questions now. So the first question is, it's been repeated. We've been getting this on Facebook Live also, as well as in the chat. It is, can you give any example of a recent case that you've argued that was, which had a lot of challenges in it while you were challenging the award before the High Court?
So, question?
Sir, give any example of a recent case that you have argued.
Sorry, can you repeat it? I didn't get it. Sorry.
So can you give an example of any recent case that you've argued in the High Court? On Section 34.
Oh, yes. I've been doing plenty of cases, as I've given during my brief interaction just now, that I have done many cases and of it, because now the arbitration, as far as arbitration is concerned, it's the most important hot topic. And parties also prefer to go in arbitration because it's a faster and, getting justices done. And in so far as the court is concerned, also not interfering much with 34. But yes, there are many Section 34 awards are also coming now. So I've been doing many, and that's what I've given this example. When last time there's another objection which appeared, it was 130 pages award. And the moment I stood up and said, I'm sorry, Mr. Sikri, you have no case. Look, the award has been given, reasoned award, everything. But since I was able to show, that in fact, there were, I won't say discrepancies, but yes, there were contradictory findings in the award itself. So the notice was issued and the award was stayed.
Thank you, sir. So the next question is, what happens in a scenario when an arbitrator ignores correspondences referred to by the parties which are otherwise vital to the case?
So that's what I said. Because in fact, if you remember, I was just referring to Justice Pratibha Singh's judgment. And in fact, there are other two judgments I have referred to High Court where arbitrator ignored those vital documents. And in fact, it happens in one of my cases. There's another case where it happened where hospital was to be set up. So now what happens is it was builder's correspondence was only mentioned in the award. However, the department, which was a public sector undertaking, correspondence not mentioned. It was totally ignored. And not only that, even whatever the correspondence was mentioned was just an annexure number was mentioned, and what was the relevancy of the document was not even explained. So naturally, the court was convinced and was able to, I was able to pursue the court on that the documents was ignored. And I was able to show prima facie because at the time of issuance of notice and the notice was issued.
Thank you so much, sir. So the next question is, it's a very small question though. It is, let's say there's an arbitral award of 5 crores, out of which only the party wants to challenge it to the limit of 1 crore. Where would the challenge of such an award lie? Before which court?
No, sorry, can you come again?
Sir, if let's say the award is of 5 crores and parties want to challenge it only to the limit of 1 crore, where would the challenge lie?
See, it all depends, if the 5 crore award is there, let's say some partial claim is allowed, 3 crores or 2 crores or even 1 crore, because the jurisdiction of High Court, say, insofar as Delhi is concerned, is 2 crore and above. But still, it really doesn't matter. if the total claims and counterclaims consolidate amount was more than 2 crores or 5 crores or whatever, then it has to be challenged in High Court only. And in Delhi High Court, at least we have it here. But of course, outside, like in Punjab and in so other states are concerned, then it depends upon the jurisdiction of that particular area. But here in Delhi, that if the award is of 50 lakhs or 1 crore, if the dispute contains more than 2 lakhs, if exceeds 2 crores, sorry, then it has to be Delhi High Court.
Thank you so much, sir. So the last question from my side before I shift to my co-moderator. If a party applied for the correction of the award, how would the period of limitation be reckoned? Like, when will it start?
Oh, if you remember, in fact, when I was dealing with limitation part is concerned, and to be precise, section 34.3 is concerned, then what happens is normally 3 months time is given to challenge the award. But then what happens is, when there is a small modification like typographical error, something like that, small is because people, they do file an application before the arbitrator and go there for clarification, then the limitation gets extended, and it extended till the date the final order is pronounced in that very application. So once that application is disposed of, your limitation starts.
Thank you so much, sir. Subhada, you may now proceed with the questions.
Thank you, Gaurav. So our next question is, can loss of profit and damages for overheads be claimed by a party? And if yes, then are the both awarded?
No, in fact, I have noticed, again with my experience, many arbitrators are doing this mistake. In fact, they are awarding both, which is actually, and if you look at it, as you said, loss of profit, and this is nothing but overlapping each other. So how can a party can be doubly benefited? It can be one, it can't be both. In fact, there's a judgment also by the Supreme Court in which judgment, there was a judgment in this, I remember that, just a second, I'll quickly mention you. Yes, when it comes to overlapping, then of course there's a judgment which is actually given SR procurement. So in this it was defined, very well defined, that you can't have, they can't be overlapping claims and you award both. So it has to be either, it can't be overlapping. So this in SR procurement, this topic was handled.
What recourse is available against the enforcement of an award during the pendency of Section 34 proceedings?
I'm sorry,
So what recourse is available against enforcement of an award during the pendency of Section 34 proceedings?
Oh, for that you have to file, separate application, seeking stay of the enforcement of the award. This is in fact, this is a very hot burning topic these days, I must say. What happens is, earlier, I would like to take, I hope I'm not taking too much of your time. I'm not exceeding my time limit. But here I would like to, in fact, point out what happens is when 1996 Act came. So when objections were filed under Section 34, and if the court is convinced and the notice is issued, what happens is the award amounts to be automatic stay of the award. So really you don't have to move any application or anything. Of course, automatic stays when the notice is issued, subject to court is putting some conditions in so far as the stay is concerned. Otherwise, it was a practice that we used to take it. It's a stay in the award and no execution would lie. Even if execution is filed, it will be Sanad, it will be lying there only. Nothing will take place. Now, what happened? Supreme Court in a recent judgment, which is that BCCI Kochi judgment, and I have a citation lying with me. This is, I think it's again a recent judgment. This is a very famous judgment, again 2018 judgment. What Supreme Court has said, it has clarified insofar as the stay of the award is concerned. that by saying that merely issuance of notice doesn't mean the awards, stand stale. In fact, I must say the Justice Nariman, who has given this judgment, has also said that it was understanding was wrong till now of the court that it will amount to stay, but no, it will not amount to stay automatic. If I use a word, automatic stay of the award once 34 is filed. Well, so definitely one has to file an application and one has to get a stay from the court and whatever conditions are imposed. Why? Because this is a money decree. Now, what happens is, one interesting fact which was done in this BCI Kochi judgment was, it was pointed out by the Supreme Court was that this would have a retrospective effect, meaning thereby all the cases which are pending under Section 34, maybe 10 years, which are pending for 10 years, 5 years, or whatever time is, they also are open to the scrutiny and there is no stay. So this happened. Now, very interesting thing happened. Now, government came out with amendment of, they introduced Section 87. I think recently it was in 2017 or 18 amendment was there. 87 was brought by the government. And it says that wherever the award is there, now 87 said that it applicabilities from the it's can't be, effect is can't be, it has to be after this, if I take, say, is the judgment. So when this judgment came, it cannot have an, effect which goes back to the judgment. So now eventually what happens is, meaning thereby, again, whatever 34 petitions, it cannot, if I use a word, legal word, retrospective effect. So they say it has to be from the day it comes, and from the amendment it comes is all the awards. So what happened? So 87 came. So again, it put the picture, back there before this Kochi judgment, that whatever awards were there, notice is issued, and the courts were under impression, or the parties were there, once the notice issued, the award signed stay will remain the same. But then interesting thing happened. Again, latest in 2019, again, Justice Ramanna, another judgment giving, where he says that Hindustan construction judgment, and there it was said that insofar as, of course, 87 was actually set aside, it was declared unconstitutional. So when the 87 was declared unconstitutional in this, the effect of BCCI again came back. So that means, insofar as stay of award is concerned, again, it has a retrospective effect and there has to be a separate application. So today, coming back in, to sum up this question is concerned, to answer this question is concerned, today, if you're filing Section 30, there has to be a separate application and stay application, I must say, and there has to be a specific order on that stay application by the court while issuing notice in main petition or main application in Section 34. So in that very application, there has to be say, if there is no stay granted and notice is issued, still doesn't mean that this award signed stay. So the opposite party who's got award in its favor, monetary claims are there, they can always file an execution. So these days I've noticed now what courts are doing is, even if they're granting stay in that applications, was because since the money decree, again, there's a Supreme Court has given few orders on that. There may not be judgment, there are few orders, 2 to 3 pages order that it's a money decree. So therefore, court normally look into that at least 50% should be directed to be deposited in the court of the total awarded amount. And normally now courts are allowing other parties to withdraw that money also. So this is how stay is now has become another important role or game which we've been playing in Section 34 is concerned.
Thank you, sir. So we'll take the last question for the evening.
Okay.
This is again with respect to very in-depth, detailed session you provided. It's about what would constitute sufficient reasoning in an arbitral award.
Sufficient reasoning.
Please, sir.
It all depends upon the complexity of the dispute which is there before the arbitrator. One really can't precise any specific rule in this, because it is the best judge is the arbitrator who is dealing with the evidence, who's dealing entire record is there before the arbitrator. So really there is no hard and fast rule insofar as this is concerned. So when it comes to this, there are various laws also have been laid down by the court looking into it. So this question, in so far as I'm sorry, in so far as concerned is, it cannot be specifically replied. It all depends on the facts and circumstances of a particular case.
It was a very enlightening session. Thanks to all our participants who were there patiently hearing through a very long session today. I'd like to thank our forum partners, LCI, who is a startup and has been hosting all these webinars, a very informative portal for all of us. I'd also like to thank our resource partners, JKGA Law Chambers. And thank you everyone for taking up time and joining us in this session. Thank you once again to all of you.
And here I would like to add, even let me also say, I want to thank you, Sumedha and Gaurav, for giving me this opportunity to dwell upon this topic, Section 34 is concerned. And thanks to all the audience for hearing me out. So thank you very much. And again, in the end, please be safe.
Thank you, sir.
Thank you so much, sir. Thank you for all the participants who join us. You can follow us for quicker updates on Lawyers Club India's Facebook or LinkedIn page. The PPT will be posted on LCI's web portal, and the recording will be uploaded on YouTube in about a week, 10 days. You can also see the recording on Lawyers Club India's Facebook page as well. Thank you everyone for joining us. Thank you, Ravi sir. Thank you so much.
Very much. Thanks. Jai Hind. Bye.